Okay, so in this lecture, we are going to be discussing some fundamental aspects of sale agreements, and these are transfer of ownership and delivery of possession. We'll also talk about a few things on agreement on the purchase price. Then we'll also compare a contract of sale versus other contracts and other important aspects such as freedom of contract, standard terms, naturalia, and other commonly used terms in respect of sale agreements. So normally when a person buys something, they wish to obtain ownership of the goods that they have bought. So if the seller is the owner, then they are obliged to transfer ownership to the buyer. However, there are circumstances where the seller is not yet the owner of the goods but intends or expects ownership. Then there is an obligation on the seller, once they have obtained ownership, to transfer ownership to the seller. So concluding an agreement of sale does not necessarily mean that the transfer of the real right of ownership will take place. It merely creates a personal right in the buyer to enforce delivery by the seller. Until delivery, the buyer has no real right in the object itself. This means that one can validly sell something which one does not own. If a seller innocently sells goods which are owned by another person, the buyer cannot sue the seller until such time as the owner recovers the goods. If a seller fraudulently sells the goods, then only then can the buyer immediately cancel the contract and sue for damages. Right? For ownership to pass, a court will look at three elements. Number one, the seller must have been the owner at the time of delivery. And number two, the seller must have intended to pass ownership to the buyer on delivery. And thirdly, the buyer must have intended to acquire ownership at the time of delivery. So ownership is different from possession and may pass at different times, right? So you can pass possession first, and that possession will then be followed by ownership. And ownership is normally passed along with the delivery of possession in most cases. So ownership of movable, immovable, and incorporeal property is all transferred differently. The transfer of ownership is determined in the contract itself. For example, if it's an installment sale, so whereby you pay in monthly installments, then you only get ownership of that particular thing after you have paid the purchase price in full, right? And where it is not stipulated in the contract, it is determined by the common law. So how do we determine whether a sale is one for cash or one for credit? So cash sale, the intention of the parties is to perform simultaneously, which means for a buyer to pay the price and for seller to deliver the thing. And under a credit sale, the intention is of the parties is to deliver first and then payment be made later. And the presumption that is used by the law is that a contract of sale is a cash sale unless it is specifically stated that it's a credit sale. So in a cash sale, ownership passes only once the purchase price is paid in full. In a credit sale, ownership passes immediately upon delivery of goods where that is the intention. So factors recognized as indicating credit rather than cash sale. Number one, postponement of payment. So where there is a definite date after delivery for payment, and security, or when security was asked for and given, right? So what this means is that if you provide something as a means to secure for payment that you have not yet made, that transaction is considered to be one of credit rather than cash. A seller and where a seller knew the goods were bought for immediate resale, and where payment of interest was agreed upon, and where ongoing practice of dealing on credit, where there is ongoing practice of dealing on credit between the parties, and when there is acceptance of post-dated checks, and when it is customary that the goods are sold on credit. So other examples of situations whereby it is customary for goods to be sold on credit are when, for example, you are buying a car at a dealership. Chances are that you get there and you'll be told that the car is to be bought on credit only. And the same applies to certain cell phones. So you may want to buy a phone in a cell phone dealer. For example, if you go to Cell C or MTN, they will tell you that no, this phone is not for cash. You have to pay. You have to pay in monthly installments, right? So that may determine whether it is customary within the type of industry that goods are sold on credit. So one of the primary obligations of the seller is to make the thing available to the buyer or to deliver the thing to the buyer. After delivery, the buyer is free to use and enjoy without permission or interference from the seller. There are exceptions to this, though, in the example of installment sales contracts. Unless it is specified otherwise, the seller's obligation is to make the thing available to the buyer. The buyer must remove at own cost and effort the goods and must be presented in a state fit for transporting. So what that means is that, if you remember the example that I gave you in class, that you go into a shop, you want to buy a television, and you choose the television, then you go to pay the purchase price at the counter. Then by the time you go back to the shelf to collect your television, you find the television broken. Whose television has been broken? So this means that you, as the buyer, right, you have an obligation to remove at your own cost and effort the goods. However, the goods must be presented in a state fit for transporting. So what that means that if the goods are now being presented to you in a state that is not fit, therefore they have an obligation to replace those goods. Okay. In the case of immovable property, the seller must provide the buyer with access to and possession of the land, right? So this basically, in the event of sale of immovable property, you are expected to be given keys. Those keys will provide you with access to and possession of that particular property. So this includes taking all necessary steps to transfer the land as well. So this means that you have to go to the deeds registry and do all the signing and so on. You have an obligation to make sure that you deliver or you provide the person undisturbed possession of the immovable property. Delivery of corporeal movable property can take a number of different forms depending on the circumstances. So you have to consider factors such as actual delivery. Then we have what is called delivery with the short end. Then we have delivery with the long end. We have attainment. We have consortium, constitutum possessorium. Then we have symbolic delivery. So all those are types of delivery of property. So the time of delivery, basically, the general rule is that the thing must be made available immediately at the conclusion of the contract. If not immediately, then it has to be made available within a reasonable time thereafter. So where the date of performance is set, the seller is in default, and the seller is in default if they culpably fail to perform by the time stipulated, especially if no specific time has been set. If no specific time has been set, then a letter of demand is required, which will place the seller in mora. In mora means that they failed to perform simultaneously they are late, right? And the price must be certain and ascertainable. What that means is that the purchase price must be determined and or determinable. It may be paid partly in kind, although the intention of the parties would determine if this is a barter, right? What that basically means is that if you want to make a payment, that payment should be determinable, as in how much are you paying. However, it is also allowed to make an exchange to pay the partially in cash and partially in kind, and that payments in kind take various forms, right? Intention, however, would determine whether this is just an exchange of goods, formerly known as barter trade, or it's actually a sale. Then, in respect of the fact that the price should be determinable, the words reasonable price, usual price, and market price can be used to indicate the price, but these terms are not ideal, right? So if a contract says you are buying a particular thing at the usual price, so that means this can be ascertained by looking at the reasonable or the usual price, or if it's the market price, then you have to look at the market price. Reasonable price is a bit problematic and not ideal, but it is also acceptable. So if the price cannot be determined, then the contract will be void. So if the price cannot be determined, therefore the contract will be void. So prices that are based on estimates, the purchase price may be determined with reference to a specific object or with reference to certain quantities. Then disproportionate values. Now let's look at whether if something is sold at a very cheap price, would that still be considered as a sale or it's a donation? However, due to freedom of contract, courts will seldom meddle in contracts where the value and price are disproportionate unless there appears to be fraud. So let's suppose I'm selling my car and I decide to sell you my car for 2,000, and yet I know that my car is worth 200,000, right? The courts will not interfere in that unless there is proof that there appears to be fraud. Because I have freedom to contract, I can sell my property to whoever I want at whatever price I wish. However, there also has to be a distinction between whether I am actually selling or I'm actually just giving it away as a form of donation, right? So you have to distinguish between a number of contracts that may look like sales, but they are actually not sale agreements, right? For example, barter trade, lease agreements, contract for work or services like a contract of employment, and software licensing. In terms of the concept of freedom of contract, parties are free to structure their contractual relationships in accordance with their own wishes. There are few circumstances where the legislator or the law will intervene. Courts will also hesitate to interfere with terms of contract because that is what is meant by freedom of contract, meaning that parties who are adults and parties of sound minds can enter into a contract at their own terms without interference of third parties. Right? National Credit Act is an example of an exception to the general rule. So it prescribes some of the compulsory content of consumer credit contracts and outlawing certain provisions. The Consumer Protection Act is another example of the regulation of contracts as well. So there are certain contracts that may be deemed illegal or unfair simply because of what is constituted in their terms, regardless of the fact that people entered into that particular contract willingly or out of their free will. So the use of standard terms and conditions is a recognized practice in business. However, in order to use these terms effectively, they have to be specifically brought to the attention of the other party or so conspicuous that a reasonable person would notice them. If a specific term of the contract has not been agreed upon by the parties, and in order to ensure the survival of the contract, natural terms are used. So examples of natural terms are that the duty of the seller is to take the duty of seller to take care of the goods until they are handed over. So the seller has a duty to make sure that the goods are in good condition until they are handed over. Then we also have liability of the seller for any latent defects. Then we also have seller's warrants against eviction. So that basically means the seller should warrant that no one is going to come and claim ownership of the goods that they have just sold to you. Then liability of seller for innocent misstatements regarding the quality of the goods. Then duty of the buyer to remove the goods, and the terms determining the transfer of the risk of accidental damage to or loss of the goods from the seller to the buyer. So you find that in most cases, when one enters into a transaction, let's suppose you've just bought furniture, it is your responsibility to now look for transport to carry that particular furniture. However, parties may also agree that it is the duty of the seller to ensure that the goods are delivered to you. Then we also have a number of commonly included terms in a contract, such as Vustut's clause. A Vustut's clause is the clause that will say the goods are sold as they are. Therefore, it is your responsibility to make sure that you are buying goods that are in good condition. So if you later then say, oh, these goods that I bought have these problems and so on, when you bought them as they are, it will be your own fault. It will be liable for any repairs that may be required, right? However, the seller must have warranted what are called latent defects. So these are defects that can be seen. Sale on approval. Sale on approval clause. Then we also have trade terms or Incoterms. Then we have free on rail and free on board, cost insurance and freight terms and so on. Okay, so that's the end of this lecture.